Hello everyone, welcome to Veranda IAS in this series of lectures of current affairs associated with social issues. The topic of the discussion for the day is very relevant and is not relevant only for this year but for all the year's examination. That is SC/ST Prevention of Atrocities Act of 1989, one of the very relevant topics for your exam. Even if you are not getting a direct question from this topic, you can quote the provisions, quote the steps taken and the measures of this act in any of your answers. The learning objectives of the day are to examine the SC/ST Prevention of Atrocities Act of 1989, to discuss the recent news regarding the SC/ST Prevention of Atrocities Act of 1989, why this topic was in news, then to describe the background of the SC/ST Prevention of Atrocities Act of 1989, in what backgrounds, what were the steps with which we got this Act of 1989. We'll discuss about, we'll list the objectives of the Act, we'll describe the criminalizing provisions. The criminalizing provisions which give the governments the permission or the authority to punish someone, that we will discuss. Then we'll discuss the establishment of special courts. After that, we will list the salient features of the Act, of the 1989 Act. This Act went through some amendments. We'll explain the Prevention of Atrocities Amendment Act of 2015 as well, the recent developments we will discuss. Then we'll list the recent court judgments, some important recent court judgments in this context. One by one, we will discuss all these points in this session today. Before that, we all know, we all are aware of the condition of the SCs and STs. In ancient days, why there is provision of reservation in educational institutions and employment opportunities, we all know this. And what is the present scenario as well? Casteism in India is not a present-day phenomenon. It is years old and it is still present. Even after so many laws, even after so many things, so many developments, still we have seen that caste discrimination in India is prevalent. Still there are people who consider even touching to some special group of people or to people who belong to some community as impure activity. Still untouchability is also being practiced in some parts of India, which is a legal offense even after that. So what are the challenges, what are the problems, what were the challenges, what were the problems, in which background SC/ST Prevention of Atrocities Act of 1989 came into existence? We'll discuss all in this session. Why this topic was in news first and foremost? See, this topic is permanent in news. Most of the times in the newspapers you can see any of the activities against the people of the SC/ST community, which is not dignityful. Any of the criminal activities, you might have heard various times that the police stations, the policemen are not writing the complaints of the people of these communities. And a number of things you might have heard, you might have read in the newspaper. So all the time this topic is in the news. Recently what happened? There was a case in which Supreme Court upheld its decision on a recent appeal filed by a person charged under SC/ST Prevention of Atrocities Act for allegedly torturing a Dalit woman in her home on 29th October 2021. According to the Supreme Court, atrocities against members of SC/ST communities are not a thing of the past. So basically, as per this act, some person was charged for torturing a Dalit woman in her home. After that, that person refiled the appeal, filed the appeal, and then Supreme Court rejected the appeal, upheld her decision. This was the whole thing, and Supreme Court said, what is important for your exam? Supreme Court said atrocities against the members of SC/ST communities. Atrocities against the members of SC/ST communities are not a thing of the past, are recent day phenomenon, are prevalent even present day, are practiced even present day. You might have seen there was a Bollywood movie, Article 15. What is it? That also tells us the worst reality of the discrimination. In the state of Uttar Pradesh, recently there was a case that the Dalit girls were hanged to death in the open premises of the villages, in the fields. There were policemen, people who reached there to take their bodies down, and the crime which they have done were, first they were girls, second they were, the so-called crimes which they have done were, first they were girls, and secondly they belong to a community which is a Dalit community. So the crimes are heinous and crimes still exist. What does the law say? What does the Act say? How does the Act criminalize these offences? We'll figure out. The background of SC/ST Prevention of Atrocities Act of 1989. The deep root of casteism in India, caste discrimination in India, we all know from the ancient times. Since a long time, caste has played a central role in India's religious and social life. Not only this, even in present day, we see the discrimination and the divisions in India's religious and social life on the basis of caste. Also, the political life of people is also affected with this factor of caste. You might have studied about casteism in politics, or we can say casteization of politics. And the second thing you might have read is politicization of caste. What is it? Cause and effect relationship again. Casteization of politics is vote bank on the basis of caste. The leader, or we can say the MLAs, MPs, the political parties choose or nominate the candidates on the basis of the caste statistics of the area. If they know that certain caste exists in this area, then they will nominate the people from that caste for the vote bank politics. So caste plays very important role, not even socially, religiously, culturally, but also politically in India. And also we can say, because of the caste or vote bank politics, this is getting more and more deepened, more and more strengthened. Initially, a person's caste was determined by his employment. Earlier, we know the hierarchy. You know the hierarchy, that it is assumed that the four castes are originated out of body of, figure of Lord Brahma. The people who got birth from the mouth of Brahma were Brahmins. From the arms of Brahma were holding weapons were Kshatriyas. From the thighs of Brahma were Vaishyas for movement or business related purposes. And then there were people who came from the feet of the Brahma. They were the Dalits. They were the Shudras, not Dalits. Dalits were under Shudras. They were the Shudras. They were given the work which was considered of low grade. So basically it was on the basis of profession. Brahmins used to chant the mantras. Kshatriyas used to fight because they were born out of the arms of the Brahma. So they used to hold the weapons. Similarly, Vaishyas used to do the business, and then there were Shudras who used to do the works which were not dignityful, we can say, or of lower grade. So a person's caste initially was determined by his employment, but over the period of the time we saw that this discrimination started getting deepened. It quickly became inherited and unchangeable. It quickly became inherited and unchangeable. What is it? The people who used to belong to certain caste were considered to be strictly from that caste. Like it became inherited, birth originated, not on the basis of profession, because in present day society or even from medieval times, ancient times, we have seen that the diversity in occupation has occurred. The people who belong to Brahmin group necessarily, we cannot see that people from Brahmin group are not doing businesses. They are doing. Necessarily, they need not to chant the mantras only or be in the temple only. And a number of vice versa cases. So, occupation got diversified, but casteism got inherited. Unchangeable. Our society now is so deeply affected by casteism that from ancient times, ancient days only, outcaste marriages are prohibited as per the customs. The people from one caste want to marry the people from the same caste, and honor killings and a number of newses you read are the consequences of this only. Next, the Indian Constitution attempted to correct historical injustices. All these injustices were there. The Indian Constitution, when we got independence, wanted to build an equal society. India was the first nation which gave in one go the right to vote to all the people who were adult, like 21 years of age earlier, 18 years now. So basically, Indian Constitution attempted to correct whatever were the problems, were the loopholes, were the discriminations in the history, attempted to correct historical injustices and create an equal platform for the backward classes. So see, there is a term equity, there is a term equality. What is the difference? Those who are equals, those should be compared equally. Those who are not equal should not be compared equally. What do I mean by this? There are certain groups in the societies, certain sections, certain communities which has burnt, which has borne or which has faced the problem of inequality, injustice and a number of discriminations. So if suddenly we are coming and we are saying everyone is equal, they are far behind in the race. This is what is the concept of environmental development. I hope you are getting this point. In environmental development, what we say that the developed nations have already developed, have already contributed their share of exploitation of Earth's resources. So now when the developing nations are the one who are developing, who are exploiting the resources, then developed nations should bear little more burden, because right now if they are not, they have already, right? Similarly here, the castes or the sections which have faced years of discrimination suddenly cannot be equated unless and until we bring them at the equal pace with the remaining society. Then only the race will start. Then only we can say that the society is equal. Why do we say that women need more rights? Women are going out, women are working, women are there in the every field social aspect. Then why do we say that she is a woman, ladies first, and we give more rights to women or more privileges to women? Why do we demand reservation for women? Similar is the case because years of discrimination was there against women. Women are progressing, but still in some societies, in some families, in some sections or some parts of the country, women aren't. So there is a need first that women should come equal to men, then only we will be talking about equality. Here lies the concept of reservation as well. Here lies the concept that why do we need reservation for women, reservation for people from the backward communities, or we can say OBC reservation, SC, ST reservation. Why do we need? Because still these people are far behind in the race of equality. First they need to come to an equal platform, then only we will be talking about equality. So, Indian Constitution attempted to correct historical injustices and create an equal platform for the backward classes following independence through the fundamental right to equality. Fundamental right to equality was given by the Indian Constitution, Article 14 to 18. We know fundamental rights, you all have studied in polity syllabus. Right to equality, Article 14 to 18. What does it say? It says that everyone is equal in front of, in eyes of laws, right? But for that equality also, we need to give some special provisions for the people who were unequal for years. Our Constitution has given those. Our Constitution has recognized this factor, particularly Article 7, Article 17, which abolished the practice of untouchability. Which abolished the practice of untouchability. Article 17 abolishes the practice of untouchability, which was one of the good steps of independent India, because we know from the time of modern Indian history only, you might have heard, you might have studied, there was Mahatma Gandhi who was saying that the untouchables are the people who are the sons of the god. He was equating the Dalits, the untouchables, as the sons of the god. He said they are Harijan. They are Harijan. Mahatma Gandhi himself used to do all types of works like cleaning of the washrooms and everything for personal work. All personal work he used to do. Why? Because he was saying that this is personal work. He wanted to promote this idea that this is your work, you do it on your own. Don't keep it for certain section of the society, some community of the society. So this is what is the concept, that from that time onwards there was practice of untouchability which was practiced in our society very widely. Article 17 of the Indian Constitution prohibited this practice of untouchability, and this was thus a very good step, very novel step. Next in this series is, despite all the provisions in the Constitution and the government efforts over the years to better the social and economic situations of SCs and STs, they remain marginalized. Still, they remained marginalized. We saw that we made laws, we got independence, we made our constitution, we wrote our constitution. In constitution we said everyone is equal. We said there will be no untouchability. Even after that we saw that they are very far in the race of development. So they are still marginalized, they are still economically backward and are subjected to various crimes, indignities, coercion and harassment. Not only this, the nature was inbuilt, the attitude of the society, co-society members was inbuilt. This inbuilt nature need some time. Over the period of the time only this can be brought into practice, that the people who is cleaning the drainage, if he is coming to your house, then you have to treat him equally. You have to give him chair to sit. Should not ask him to sit on the floor. So this is what is in practice. This is what comes with practice. So they are subjected to, still they were subjected to various crimes, indignities, coercion and harassment. Here lied the need of some law, some act. In 1989, the Parliament passed the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act, hereinafter Act, which recognized this condition. So basically the Parliament finally, 1989 was the year, passed the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act. Now Act. Now it became law. It recognized the condition that yes, still there is a lot to be achieved. Still there is discrimination going on. What are the objectives of this act? Thus, the act's goals make strong. With the coming of this act, what happened? Indian states, Indian government's commitment was there to bring everyone at par, to bring everyone at an equal level. We had right to equality. We had number of things in the Indian Constitution that tells us, that says, or that shows the determination of Indian government to bring or to have a more inclusive, more equal society. So with this act, this got complemented. Thus the act's goal make strong the Indian state's commitment to bring justice to SC/ST groups through affirmative action. Through affirmative action, in order to enable them to live in a society with dignity and self-esteem. First and foremost, what is required is dignity, is self-esteem, is social acceptance. Then economic conditions, economic well-being also comes. Free from fear of violence or repression by the dominant castes. Free from the fear that they might face any violence. We were in independent India. We knew that now this should not be the case. Still after that, the people from the SC/ST community were facing the crimes. Even in present day we have seen multiple times, even we have laws taking actions. After that there are crimes against the people of SC/ST communities, against the women of SC/ST community, very prevalent. Free from the fear of violence or repression by the dominant caste. The Supreme Court of India also emphasized the relevance and importance of this act. So, this act of 1989 was one step ahead, commendable step to recognize that still there is problem in the society which need to be tackled. The act's provisions may be classified as shown here. SC/ST Act has some provisions of criminal law. Then comes provisions for relief and compensation for victims. Then comes provisions that establish special authorities for the implementation and monitoring of the act. What is it? SC/ST Act. First and foremost, if someone is committing the crime, he should be punished. Provisions for criminal law. Second, the crime is committed against someone. The victim should get some help, get some relief. Provisions for compensation and relief for victims. Third, provisions should be there that in future these crimes should not get conducted. For this we need some bodies, we need some authorities, that is provisions that establish special authorities for the implementation and monitoring of the act. Whether this act is being monitored, is being implemented or not, some authority should be there, and this act says special authorities will be established. So we will not discuss all the provisions, we will discuss criminalizing provisions or some provisions which were in news which are important for you. Section 3(1), punishment for offences of atrocities. What does this act say? What does this act say? Whoever is not a member of SC/ST, whoever is not a member of SC/ST disrespects any late person held in high regard by members of the SC/ST via words written or spoken or through any other means will be punished. Whoever is not a member of SC/ST disrespects any late person held in high regard by members of SC/ST either by words, written or spoken, or through any other means will be punished with imprisonment for a term not less than 6 months but not more than 5 years and a fine. So what does it say? It says disrespect to the people of SC/ST community is also a offence. People will be imprisoned for this. Section 4 discusses the consequences of a public servant's failure to perform his or her obligations. Section 18 deals with the rejection of anticipatory bail under Section 438 of the CRPC, Criminal Procedure Code. The establishment of special courts. What is it? Section 14 of the Act states the establishment of special courts. The Act says there should be establishment of some special courts. What is it? For the purpose of providing for speedy trial. For the purpose of providing for speedy trial, the state government shall, with the concurrence of the Chief Justice of the High Court, by notification in the official gazette, specify for each district a court of session to be a special court to try the offences under this act. There should be special courts for the speedy trial. That is also one of the important provisions. Some salient features of SC/ST Prevention of Atrocities Act of 1989. There are new forms of offences that are not covered by the IPC or the 1955 Act protecting civil rights. It punishes offences against SC/ST people. It then gives extra protection and advantages to the victims who bear the burden of the offences against them. It refuses to grant anticipatory bail. To speed case adjudication, it established special courts and a special public prosecutor. To speed case adjudication, it is having provision to establish special courts and special public prosecutor for this purpose, for speedy trials we can say. Compensation, relief and rehabilitation are all available to victims of atrocities or their legal heirs. So also this act gives some compensation, some relief and then rehabilitation facilities to the victims. 2015 Amendment Act introduced some amendment. The Scheduled Caste and the Scheduled Tribes Prevention of Atrocities Amendment Act 2015 is widely recognized as a crucial step in re-establishing SC/ST's faith in the law, also popularly known as Amendment Act, 2015 Amendment Act. It contains other cases of atrocities committed against SCs and STs. It widened the arena of this act. It contains other cases of atrocities as well committed against SCs and STs. It also includes additional IPC offences, for example, injury, severe hurt, intimidation, kidnapping, that have a maximum sentence of less than 10 years and are committed against SCs and STs as punishable under this act. It has further widened the definition of offences. It also includes additional IPC offences as punishable under this act. The Amendment Act defines the phrase willful negligence. Willful negligence with respect to all levels of public officials from complaint registration through the desertion of duty under this act. This says, this act went one step ahead. It said that if the complaint is not getting registered at all the public levels, if at all the levels of public officials, if the member of or victim of SC/ST community is not able to get the justice, that is willful negligence. For complaint registration through the desertion of duty, till the desertion of duty, that will be considered as willful negligence. Some important recent court judgments will discuss. 2020 Hitesh Verma versus the state of Uttarakhand. What is it? Hitesh Verma versus the state of Uttarakhand. The court held that offence under the act cannot be established unless there is an intention to humiliate a member for the reason that the victim belongs to such caste. The court said that under this act, the offence cannot be established unless it is sure there is an intention to humiliate. The offence was done because the member belonged to certain community, to such caste, till the time the offence will not be considered. If the offence is done with this emotion or with this faith to humiliate the other person because he is from scheduled caste, he is from scheduled tribe, then that is a offence under the act. This is the development in Hitesh Verma versus the state of Uttarakhand. Then next comes Ram Avatar versus state of Madhya Pradesh 2021. The court ruled that its inherent powers under Article 142, inherent powers under Article 142 of the Constitution or that of the High Court under Section 482 of the Code of Criminal Procedure can be invoked to quash proceedings under the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act of 1989. Can be invoked to quash proceedings. Important. Can be invoked to quash proceedings. So this was all for today about the SC/ST Prevention of Atrocities Act of 1989. The recent news regarding the SC/ST Prevention of Atrocities Act of 1989, the background of the SC/ST Prevention of Atrocities Act of 1989, the objectives of the Act, the provisions of the Act which were criminalizing, the criminalizing provisions, the establishment of special courts, the salient features of the Act, and then prevention of Atrocities Amendment Act of 2015. Then we discussed some recent court judgments as well. This was all for today. I hope you all enjoyed this session. We'll continue from here. Till then, stay tuned, keep studying. Thank you so much.